where defendant Zachery Gilbert is back in court at this hour. He's facing sentencing for the shooting death of his former girlfriend. Police say that Gilbert shot Brianne Otley after an argument. Now, the victim's family claims that Gilbert delayed calling 911 for 45 minutes. Now, Gilbert avoided the death penalty by pleading guilty to a lesser charge of involuntary manslaughter on the day that his murder trial was set to begin. Now, the last-minute plea deal was a shock to the victim's family, and several of them expressed their frustration to the judge. Now, here's how that played out in court last month.
Florida case 24 CR 212, State of Ohio versus Zachery Gilbert.
Plea was offered wherein the defendant would enter a plea to a lesser included offense of involuntary manslaughter as contained in count 1. The state would be dismissing count 2. Pursuant to the plea, the state notified the victims of the potential of a plea. We were notified they were not happy.
I am 1,000% against this plea deal. There is proof. There is proof after proof after proof that this man is guilty. I better sit down before I get out of line.
It's not fair to the family, to my sister, to her kids. No plea was supposed to be given. It's their job to fight these cases. Holiday or not. She's still dead.
It wasn't an accident. She had a 90% chance to still be alive if they would have simply just called the cops after he shot her, instead of laying there for 45 minutes.
According to the proposed plea, you were willing to plead guilty to count 1, the lesser included offense of involuntary manslaughter. That's a felony of the first degree. It comes with a potential sentence of a mandatory prison term of 3 years minimum, 16 and a half maximum. So Mr. Gilbert, with regards to count 1, the lesser included offense of involuntary manslaughter, felony of the first degree, how do you plead?
Guilty.
Court accepts the defendant's plea, enters a guilty judgment against the defendant. Everyone, thank you for being here. Hard to swallow. I understand that. But I wish you well.
Tough day for that family. According to that plea deal, he faces anywhere from 3 to 16 years. He will get tacked on an additional 3 years. There was a gun enhancement to this crime, so that'll get tacked on to whatever sentence the judge gives him. So potentially somewhere between 19 years in prison he could get. Let's get you into court now for that sentencing hearing for Zachery Gilbert.
On the record, case 24 CR 212, State of Ohio versus Zachery S. Gilbert. We're here for disposition and sentencing on a conviction handed down back on December 19th, 2025, with the charges of involuntary manslaughter, a felony of the first degree with a gun specification. In the courtroom is Ms. Quigley on behalf of the prosecutor's office, Mr. Pendle, defense counsel. Mr. Gilbert is present as well. Counsel, have you had a chance to review the pre-sentencing investigation? Do you have any changes to that document, Ms. Quigley?
No, Your Honor.
Mr. Pendle?
I reviewed it with no changes, Your Honor.
Okay. Court has reviewed it in its totality as well. Before we get to recommendations on sentencing, the court will acknowledge that the state of Ohio did file a state sentencing memorandum, which the court has reviewed. Ms. Quigley, are we in compliance with Marcy's law? And do you have any victim representatives who would like to make a statement in court?
Yes, Your Honor, we are in compliance, and we do have victim representatives who would like to make statements.
If you'd like for them to come up to council table so they're properly on the microphone, I'd be happy to entertain their comments at this time.
Thank you, Your Honor.
Please state your name, and you're welcome to make any statement you'd like then, ma'am.
Candace Hall. Brianne was my niece. Your Honor, Brianne's family should not have to ask for the maximum sentence for the person who killed her. This was murder. The prosecution's decision to offer a plea with a maximum sentence of 16 years does not deliver justice, but he should receive the maximum allowed. An accident is an unfortunate event that occurs unexpectedly and unintentionally. This was not an accident. It was a premeditated act. He told several people he intended to kill her. He had a gun. used a pillow to muffle the shot, left her bleeding while he planned his story, and then fled. None of these actions alone are defined as unexpectedly or unintentionally, let alone all 6 of them can only lead to premeditated murder. He sentenced her family to life when he took hers and failed as a human being to call for help. Brianne lay there bleeding. No one to comfort her, hold her hand. No one on the way for 30+ minutes to help her. Was she crying? Was she screaming for help? Trying to get up? Unconscious? What was she thinking? The things she had to think about lying there with no one to help her. Her children, Caden, Mariah, and John. Her grandmother, Pearl. Her grandfather, Dave. Her mother, Michelle. Her sister, Latasha. Her brother, Nick. The numerous family members she has. Her dad, John, who she lost at the age of 21. It has been approximately 2 minutes since I started this speech. Imagine being shot, lying here, just those 2 minutes, bleeding, in pain, scared, crying, no one helping you. What would you do? Where would your thoughts be? You cannot even begin to imagine. She fought her whole life. The prosecution let her down. Please do not let her down either. Zach, I believe in God and karma, and I believe one of them will ensure you never walk out of prison.
Thank you, Ms. Hall.
I'm Michelle Otley, Brianne's mom. I have a couple statements from 2 of her children they'd like me to read. It's kind of scribbly, so. This is from Mariah. It says, to Judge, I really think Zach should be in there for life because of what he did to my mom, and I feel upset every day, and I really do not like what he did. And I know that he loved her, but too much, and I'm sorry, it's kind of hard to read. Too much, and please, Judge, put him in jail forever. Please, he took my mom away from me, and I would always kiss my mom goodbye or goodnight. And he took her until he took her away from me and my siblings. So please let him do life. And it's really sad without my mommy. So Judge, please. My whole family is upset because of him, and I cry because I miss my mom, and she was just the best, and we would have so much fun. So Judge, give him life in prison. Sincerely, Mariah, her daughter. And this is from John. Dear Judge, when Zach took my mom, I was sad. If I could have one wish, it would be to have my mom back. Judge, can you please help my family? I mean, I lost my mom, and so did my family. Can you help me out? All I want is him to be in prison for life. I am sad, Judge. Sincerely, John Otley. I'm sad, sad, sad. What he did in no way, shape, or form was an accident. It was murder. He left her lay there to die. He could have called 911 and she could still be here. It's horrible what these kids have to go through now. I watch it every day. They're broken. They're 11 and 12 years old. They should not be broken. And they are because of what he did.
Thank you, Ms. Otley.
From the mouths of her children asking for life in prison for this defendant for killing their mother. Again, he's not facing life in prison. The most he could get under these circumstances, about 19 years or so. All right, we're going to take a break. When we come back, the grandmother has the opportunity to speak. And trust me, folks, she doesn't hold anything back. More from the sentencing for Zachery Gilbert in Ohio when we come back. Keep it here on Court TV. Did you? Welcome back to Court TV Live. I'm Michael Ayala. Now back to Ohio, where confessed killer Zachery Gilbert faces sentencing. Gilbert pleaded guilty to involuntary manslaughter in the shooting death of his on-again, off-again girlfriend, Brianne Otley. By pleading guilty, Gilbert avoided a possible life sentence. He now faces 3 to 16 years in prison for that involuntary manslaughter guilty plea. Let's go back in now for more of today's sentencing hearing. Brianne's grandmother is now giving her impact statement.
Losing my granddaughter, Brianne did, meant, etc. to me and our family. I cannot find the words to describe because there are so many emotions going through my brain that I am unable to pick just one. Zach, I definitely know that she did not deserve to die in the manner in which you and God both know she did. Since you shot her, you have showed no remorse whatsoever. Just imagine how scared she was, knowing that you and your mother were there and not helping her or even calling 911 for help. There again, you have demonstrated and proved what a selfish individual you are. You were more worried about yourself, saving yourself by running away. I feel you deserve a much stiffer sentence than what you will probably receive today, especially when I see and hear the grief. Her 3 children, Caden 12, Mariah 11, and John 9, ages that they were at the time of her murder, are sentenced with for the rest of their lives. When they come up and ask me, Gigi, why did Zach shoot our mom? He said he loved us. Zach, how would you explain that? Brianne showed you love, understanding, support, and she even opened her heart, home, and children to you. We kept encouraging her to leave you and kick you out, but she kept telling us over and over that everyone deserves a second chance. Look what giving you a second chance got her. I can say that she was a beautiful, loving woman inside and out, that God gave us the privilege to raise. And to talk to daily. See, Zach, she was not just one of our many wonderful grandchildren we are blessed with. We raised her like she was one of our children. I am thankful for the fact that she is at peace now and won't be suffering anymore. I pray she is in God's hands, knowing that she is loving every minute of it. So in closing, Your Honor, I'm asking that you consider Zach's past and present actions thus far, with his acting out in violence and appearing to feel that rules do not apply to him. Also, the seriousness and the grief he has caused our family, Brianne's children, and all the special and small things in her children's lives that she and them were robbed of. One thing for sure, Your Honor, she loved her children. So when you are deciding his sentence, that you feel the maximum amount of sentencing is adequate. Thank you for your time and the court's time, Your Honor.
Thank you, Ms. Hall.
Right, so grandma slash mom really laid it out. As she said, it sounds like she and her husband raised the victim in this case. Let me bring in my guest, still with us, criminal defense attorney, former prosecutor Jack Rice. Jack, you know, this family, and you can feel it in their statements, they're hurt, they're angry, they feel betrayed by prosecutors. We've talked a lot about victims' rights and trying to give them more say in the outcome of these cases. This is one where clearly prosecutors didn't seem to sort of listen to what the family had to say. They clearly felt this was a murder case. However, they pled it to an involuntary manslaughter. What are your thoughts?
Yeah, I'm really scratching my head on this one, Michael, because one of the things that happens is that prosecutors are supposed to listen to victims, the families, the survivors, because they are a piece of this process. But in the bigger picture, the prosecution does not represent the family. The prosecution represents society. And so the purpose is they're not there to champion, per se, the survivors themselves. They're there on behalf of society to do this. Now, that doesn't help the families. It doesn't make them feel any better. And the problem is we may never know exactly why it is that the government, why the state decided to do what it is that they did. Sometimes what happens is the state doesn't have a case that is as strong as the family thinks that it is. Sometimes they may not have witnesses who are cooperative. Sometimes they may actually have evidence that they actually didn't properly deal with, and they may have problems with getting it into evidence in the first place. You never know why it is they make those decisions. And at the same time, we realize, think about the vast number of cases that resolve short of going to trial. The problem is, of course, is you're balancing the idea of judicial economy, trying to make sure you can deal with the thousands and thousands and hundreds of thousands of cases across the country, while at the same time, you have these grieving family members who are watching this saying, you don't understand. I'm going to carry this for every single day for the rest of my life. That is the tension, the pushback that goes when you go one direction versus going the other.
Jack, I got to say, all those things make 100% sense, and I know them to be true. But as I look at this case where this guy pled, you know, he told them, he had confessed to doing this. You had neighbors who saw him leaving, running the house with a gun, running out of the house with a gun. He tells them where he left the gun. They find the gun where he left it. He even tells them, I had been drinking. I went back to the house because I thought she was cheating. They had an argument. He shot her. The best you could come up with under those circumstances, if you want to talk about judicial economy, is manslaughter. But they went involuntary manslaughter. Is there any way, again, that connotes some sort of accident, you know, and we talk about the family's talking about he left her there for 45 minutes. That alone, we've seen in other cases. You can infer intent just from that. What possibly do you think prosecutors might have been thinking here to even go to involuntary manslaughter rather than manslaughter?
Yeah, it shocks me too. And you're so right. I'm feeling the same thing. You know, we've seen circumstances where, in my opinion, I've seen prosecutors actually overcharge, saying, we think we can get them on something that we can't. But in a case like this, they decided to negotiate down not just one step, but multiple steps in order to offer that involuntary manslaughter. You have to ignore evidence that they had in their hands. That would have been really simple to drop into a jury box and say, look at all of the planning that he went to. Look at all of the opportunity that he went to. Look at all of the things that he could have done and chose not to do. And yet that would have been easily enough for manslaughter, let alone that involuntary manslaughter that they negotiated. It's extraordinary. And by the way, notice the 3 year is a mandatory minimum. They didn't even come back with a floor that said 15 years. Right. They said, plead to this, and we'll just leave it open-ended. That's shocking to me.
Yeah, it's shocking all the way around. Again, we don't know all the details on this case, so I want to definitely say that. But again, it does seem shocking. All right, Jack, stand by. We're going to take a break. We'll have more of that victim's impact statement from the sentencing hearing for Zachery Gilbert in Ohio when we return. Keep it here on Court TV.
An affair with the family's au pair lead to double murder.
It was him. I'm gonna kill her. I'm gonna kill her.
It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV. Tonight on Closing Arguments, a widow who wrote a children's book on grief stands accused of poisoning her husband. We have key takeaways from today's big hearing in the case against Corey Richins.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
We're in Ohio this afternoon, where a man will soon learn his sentence for the shooting death of his on-again, off-again girlfriend. Zachery Gilbert pleaded guilty to involuntary manslaughter in the shooting death of Brianne Otley. He faces a 3 to 16-year sentence in prison. Let's go back in now. The state is now making their final argument for sentencing.
Your Honor, as the state laid out in the sentencing memorandum, the state's position is that the maximum sentence in this case is appropriate, which is 11 years up to 16 and a half years for the charge, as well as an additional 3 years for the gun specification. In reviewing the purposes and principles of sentencing here in Ohio, the court is well aware of what to look at. The first is seriousness and recidivism factors. In this case, the defendant killed Brianne Otley. The defendant's relationship with the victim facilitated that offense. Nothing demonstrates that the defendant's conduct was less serious than conduct normally constituting the offense. The defendant used Brianne's own gun to shoot and kill her. He refused to seek medical assistance for her after he shot her, allowing her to lay on the floor and die. With regards to recidivism factors, in this situation, the defendant's extensive criminal history for a young man his age is supporting of the maximum sentence. Defendant has numerous convictions in which he was given probation repeatedly, and he repeatedly failed probation and had to serve his time. His first offense was a falsification. He was allowed to plead to an obstruction. He violated his probation on that. A drug offense. He pled to a drug paraphernalia, granted probation. He violated his probation on that. The next was an underage consumption. He pled to a disorderly conduct. Again, given probation, violated it, and ordered to serve his time. The next was a domestic violence threat, reduced to disorderly conduct, given probation, violated it, served his time. The next was an assault. He pled to a disorderly conduct again. And in that situation, because it was misdemeanor of the 4th degree, they issued a warrant block, which meant he had certain things to do before he could get his license back. The next case was a domestic violence underage consumption. He pled guilty to an amended charge of assault and disorderly conduct, given probation, violated that, and ordered to serve his time. The next was a criminal damaging. He got a disorderly conduct and ordered restitution at that point. The next was a theft offense. He pled guilty to that, given probation, violated it, ordered to serve his time. The next, obstructing official business and disorderly conduct. He pled guilty to the obstruction. The disorderly was dismissed, granted probation, again, violated, ordered to serve his time. Then he had a felony case, the vandalism case, in which is what he was on community control at the time of this offense. He was granted an intervention in lieu of conviction because he had no prior felonies. Even with his incredibly poor track record in municipal court, he was given that. And what happens? He's not compliant with his treatment plan. He continues to use drug and alcohol and violate the law. Shortly after being granted community control, he was violated, and he was incarcerated for a time until he was sent to a rehab facility known as the Treaty House. He was then, again, violated later when he failed to report and arrested for a public intoxication. And then finally, on July 29th, he was charged with a criminal damaging. He violated community control and his intervention program again. He was not violated by his probation officer at that time. However, the probation officer sent him back to the treaty house. And interestingly enough, the probation officer drug screened him, and he screened positive for cocaine and opiates. Shortly after that, January 27th, he was for public intoxication. That case was dismissed. That was in Indiana. Then the criminal damaging and failing to stop after an accident. This is the July 24th incident in which the defendant and Brianne had broken up. The defendant, for whatever reason, chose to ram his car into her car and flee the scene of an accident. Again, he was not violated when he was charged with that offense, however, sent to the treaty house. And again, he had used opiates and cocaine. He chose to leave the treaty house in violation of probably what probation had done, and he chose to violate municipal court's no contact order that they had placed on him in the criminal damaging and leaving the scene of an accident charge, because he was ordered to have no contact with Brianne Otley. But again, he chose to violate that and moved back in with Brianne. Brianne and the defendant had a relationship that probably was best called toxic. They were together. The family did not want them together. But she kept giving him chances. For whatever reason, she kept giving him a chance. The problem is that on the date that he killed her, she was trying to leave him. That was obvious by how she was getting her property, trying to get out of the house and leave him. And he chose not to let her leave. And he chose not to let her leave in the most severe way when he shot and killed her. If you look at the municipal court documents, it keeps saying, get a job, get a job, get a job. And he would do that for a while, but then he'd, again, start drinking, start using drugs. And when he did that, he hurt people. He absolutely hurt people. The criminal damaging case was dismissed because he killed Brianne. He pled to the failure to stop after an accident and was sentenced accordingly. Defendant has consistently rejected attempts to be rehabilitated and make positive changes in his life. At the hearing where there was a motion to modify the bond, the state listed the numerous times that he has violated while he's been in jail. He cannot comply with basic requests and court orders, and even jail requests and orders. He would not listen to the court order to get drug and alcohol treatment, to get a job, to have no contact with Brianne Otley. He chose to violate that. And he continued to abuse alcohol and drugs and hurt others. He has demonstrated a long and consistent pattern of this. The state does not believe he has...
All right, all that the prosecutor's saying, it just begs the question, why did they go to trial on murder? All right, thanks to Jack Rice for joining us. As always, folks, stick around. Coming up, we're going to bring you more from that Zachery Gilbert sentencing. Plus, Court TV's Kelly Craft joins us live from Virginia for that verdict watch in the Brendan Banfield trial. 8 minutes, 8 hours in. Keep it here, Court TV.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are on verdict watch in the au pair affair murder trial for Brendan Banfield. The jury has been deliberating now for 8 hours and 16 minutes.
Over 2 days. They started on Friday. They continued this morning. The prosecutor, of course, says that Brendan plotted with the family's au pair to come up with an elaborate plan to kill his wife, Christine, and to kill another man, Joseph Ryan.
Now, Banfield admitted on the stand that he shot Ryan, but said it was because he found the man stabbing his wife in their bedroom. Now, in the defense's closing argument, Banfield's attorney says the au pair, Juliana Magalhaes, is the one who actually came up with that plot.
And now it's up to the jury to decide which version of the events they believe, really to decide, do they believe her, the au pair, or him, the defendant?
Yeah, it's pretty sophisticated for her. I don't know. It's hard to believe. But let's bring in our reporter from the field live from outside that courthouse. It's Court TV legal correspondent Kelly Craft. All right, Kelly, we haven't heard many personal details about that other victim. We keep calling him the other victim, Joseph Ryan. Now, his mother actually spoke recently. What can you tell us about that?
Hi there, Michael and Judge Ashley. Yes, his mother, Joseph Ryan's mother, spoke recently to a local TV station here, WUSA 9. They went down to Florida and they conducted an interview with her. And she had a lot to say about her son. We're going to play a little clip in just a moment. But I can tell you, inside the Fairfax County Courthouse, really not a peep so far from the jurors. But we are just coming up at the top of the hour at 4 o'clock. And so from my understanding, they are going to be checking in with the jury to just kind of gauge as to where we are, because they could stay till about maybe 4:30, 5 o'clock. They are going to ask them if they would like to stay even later than that if they haven't reached a decision at this time. It is not typical fashion here for them to bring in any dinner. They, of course, did provide them for lunch, so it will be up to the jurors if we don't have a verdict in the next half hour or hour, if they do want to stay past normal court operating hours here. But let's go ahead and talk again about Joseph Ryan's mother and that interview that was done by the local TV station, because she talked about his likes. It's kind of an uncomfortable conversation you would think that a mother might have with her son, but she was very open, talking about things that her son had shared with her, about things he had preferences for in regard to his sexual likes. But she also had this to say in regard to what her reaction was when she found out that her son had died. Let's listen.
I remember when I got the call from the detective. He called me and he told me that my son had been killed. And I just know when he told me that I could hear my own voice screaming.
Now, Joseph Ryan's mother has not been inside the courtroom. Her sister, so Joseph Ryan's aunt, has been inside the courtroom, along with many members of Christine Banfield's family. And then, of course, Brendan Banfield's father and his wife have been here as well. Michael, Judge Ashley.
All right. Now, Kelly, when Brendan Banfield took the stand, what did he have to say about that other victim, Joseph Ryan?
Ooh, interesting question, Judge Ashley, because defense counsel was asking him, this was on the direct examination, and he was asking him about knowing Joseph Ryan, but this was right before he walked into the bedroom. Brendan Banfield would have walked into the bedroom, and so Brendan Banfield is describing how he heard this skin-on-skin noise coming from the bedroom, and then he used his right foot to kind of prop open the door, and that's when he saw a man on top of his wife, and he said, making kind of a stabbing motion with the knife toward her. His defense counsel then asked him, well, do you know Joseph Ryan? Had you ever seen of him, heard of him before? Let's hear what he had to say on the stand.
Had you ever seen Joseph Ryan before?
I had never seen Joseph Ryan before.
Had you ever had any communications with him before?
On February 24th is the only time I had communications with him in that room.
So Now, jurors could have asked to have that knife brought back so they could take a look at it. From our understanding, they have not asked to see the knife or the firearm. The judge told them before they began deliberating on Friday that if they wanted to see any of those items, that they would be brought back for them. They could not handle those items. The bailiff would handle them, but they could see them if they wanted to. From our understanding, they have not asked to see anything. And of course, we've not heard any questions from the jurors either. Michael, Judge Ashley?
Kelly, one quick question before I let you go. Do we know if they, just as a matter of course, have those phone records, the one that were testified to by the expert for the defense, with them back there? Because that could be what they could be going through.
They have all of that back there, Michael, yes. So they have a lot of exhibits to look through. And when defense counsel gave his closing argument, Michael, he told them and he urged them, basically pleading with them, to take a look at all of those, because he says when you take a look, for instance, at some of these timestamps in the evidence that Juliana Magales gave on the stand, he says that doesn't add up. So I can tell you from being inside that courtroom and watching some of those jurors take notes, and they were taking some detailed notes, there are some of them that are probably analyzing those very closely.
All right, that makes a lot of sense.
Yeah, a lot of documents. I can't imagine how long that will take to go through it all, Michael.
Yep, all right, Kelly, thank you so much for that report. Truly appreciate it. All right, folks, let's get back to that sentencing hearing going on in Ohio for defendant Zachery Gilbert.
He's facing sentencing for the shooting death of his former girlfriend. Let's pick it up right where we left off with the prosecutor addressing the judge.
The state does not believe he has genuine remorse. His claim that he was intoxicated, wanting to self-harm, are hollow statements and not supported by the facts. If he was truly at a position where he wanted to self-harm, he had a gun. But as soon as he killed Brianne and he fled that residence with the gun, he disposed of it almost immediately and then took off. So his claim that he was going to self-harm is a hollow claim. He did not want her to leave, and he made sure she didn't. He ran from the scene, disposed of the firearm, and when he was finally apprehended later, he had time and started blaming Brianne. Oh, it was her fault. It was her fault. The defendant's long criminal history does not mitigate his actions. In fact, it's the other way. From 2017 through 2024, he has had an inability to change his behaviors when given repeated chances. Defendant never served in the military. The court has full discretion to impose any sentence within the authorized statutory range. And in this case, the maximum sentence is 11 years with an additional 5.5 years pursuant to Reagan-Tokes. The court's not required to make any findings to give its reason for imposing whatever sentence it determines, even a maximum sentence, other than giving deference to 292911 and 292912 of the Ohio Revised Code. The defendant's conduct in this case is completely in character. He drinks, he abuses drugs, and he hurts people. Only a lengthy incarceration will stop the defendant to protect the public and from the defendant's actions. The impact of the defendant's actions will have, again, as the family stated, long-lasting effects on his mother, on Bree's mother, on her sister, on her children, on her grandparents, on her entire family. His selfishness in only thinking about himself cost Brianne her life. The state believes anything less than maximum would demean the seriousness of the defendant's conduct. It's necessary to protect the public and punish the defendant. His defiance has to be dealt with, and his unwillingness to make meaningful changes with any type of supervision is appropriate for a maximum sentence. The state, again, does not believe that anything less than the maximum sentence will be able to be appropriate to show or rehabilitate this defiant and unwilling defendant. Thank you.
Thank you. Mr. Pendle?
Thank you, Your Honor. Your Honor, this case represents an absolute tragedy for everyone involved. Brianne Otley lost her life. Her survivors lost a mother, a daughter, a granddaughter, a niece, a sister, and a friend. And there is nothing that this court can do to make her family whole or to bring the victim back. And for that, the family does have my true condolences in this matter. Your Honor, the law differentiates between an accidental killing and a purposeful killing, notwithstanding the fact that in either incident, a victim was unjustly killed. From day one, Mr. Gilbert has said that the shooting was accidental. He told police that he had the gun because he was suicidal, that the victim was trying to take it away from him, and that during the struggle, the gun went off. Only one gunshot was fired that day. Now, I understand that some people in the courtroom, including the family of the victim, believe that the shooting was intentional. We're not here today to debate the evidence. The defense was prepared to go to trial and present evidence that the shooting was accidental. The state amended the charge for murder to manslaughter. Mr. Gilbert pled to an accidental killing. Mr. Gilbert is before this court today to be sentenced on an accidental killing. Now, I've gotten to know Mr. Gilbert fairly well over the 15 months that I've been working on his case. Even as a young man, he has experienced many struggles in his life, including struggles with substance abuse. Mr. Gilbert has previously attended and completed an inpatient treatment program in Loveland, Ohio. And like many people who struggle with substance abuse, he's experienced periods of sobriety and periods of relapse. In every interaction I've had with Mr. Gilbert, he has been polite and respectful. He has been understanding of the delays in his case, and he has been considerate of my time and my obligations for other clients. He has, on many occasions, expressed remorse for what occurred. He has displayed empathy and perspective in recognizing how his actions have affected the victim's family and the grief that he has caused them. These are redeeming qualities that show Mr. Gilbert has the potential to rejoin society as a rehabilitated man. The state and the victim's family are requesting the court impose the maximum sentence, or in some cases above the maximum sentence. In support of those recommendations, the state and the victim's family recite allegations about facts of the incident to suggest that it was a purposeful killing. Again, these allegations are highly contested by the defense and not reflective of the offense to which Mr. Gilbert pled guilty. Again, the defense was prepared to present a great deal of evidence at trial that would show the killing was accidental. The state is essentially asking that this court sentence Mr. Gilbert as if he committed a murder despite him being convicted of manslaughter. By statute, this court is required to impose the minimum sanctions that accomplish the purposes of felony sentencing. Maximum sentences are reserved for the worst type of offenders and the worst versions of the offense. While Mr. Gilbert certainly caused great harm, it was not his intention to do so. None of the aggravating factors relating to an offender's position in the community, involvement in organized crime, or motivation by prejudice apply in this case. Mr. Gilbert does have some significant criminal history, as evidenced by the state, but it is almost exclusively misdemeanors and petty offenses: disorderly conduct, underage consumption, drug paraphernalia. Again, Mr. Gilbert has expressed great remorse for his offense. Significantly, he has never denied wrongdoing. He's never claimed that he wasn't the shooter. He's never claimed that it was self-defense. He never said that it wasn't his fault. He simply insisted that he be treated fairly and that the punishment in this case fit the crime. Mr. Gilbert admitted to accidentally killing the victim. Mr. Gilbert pled guilty to manslaughter. Mr. Gilbert is before this court for sentencing on manslaughter. And this court should not be persuaded to impose a maximum sentence based on unproven allegations that the killing was purposeful. This court must impose a fair sentence on Mr. Gilbert based on the crime he committed, not the crime that others speculate he committed. And for those reasons, we ask that this court impose a fair sentence for the crime of involuntary manslaughter. Thank you, Judge.
All right, Zachery Gilbert, he is going to be the one addressing the court next. I can't wait to hear what he has to say, Michael, as I sit and watch, and so many people are upset with his plea.
Yeah, no doubt. And he's claiming it was unintentional, so that's why it might be where it came from. We're also keeping an eye on that courtroom in Virginia. As you can see, they've been deliberating 8 hours and 31 minutes. But we also heard from our producer on the ground that the bailiff checked on them to see where they're at 4 o'clock, and they said, hold on, give us 15 more minutes and come back and check. So speculation is they could be close, so we'll keep you updated on that. We're going to take that break, come back, keep it here on Court TV.
Tragic murder of Keith Canero and his entire family.
This one is the most brutal case that I've seen in my experience here.
The Mansion Murders Trial. Live coverage today on Court TV.
Tonight, on closing arguments, a widow who wrote a children's book on grief stands accused of poisoning her husband. We have key takeaways from today's big hearing in the case against Corey Richins.
Closing arguments tonight at 8, 7 Central, only on Court TV.
We have a lot going on, yes, Michael. You announced that we knew the jury had said to the bailiff, well, 4:15, check in with us again. Well, that's happened. Now, this is in the case against Brendan Banfield, the au pair affair murder trial. You see the clock is at 8 hours, 37 minutes of the jury deliberating, and we now know the jury said we need 5 more minutes. So that's where we stand on that. We are going to certainly keep an eye and get you back into that courtroom as soon as they are ready.
Yeah, and as I read the tea leaves, that suggests they're close.
Yes, I would agree with you.
That's the sense you get in that situation. And of course, as soon as anything happens in that courtroom, we're going to take you there live. But right now, I want to get you back to Ohio. Defendant Zachery Gilbert is in court this afternoon for sentencing in the shooting death of his former girlfriend. He pled on the day, the day of trial. He pled guilty to involuntary manslaughter, was initially charged with murder. I want to take you back into court now because he, the defendant, is addressing the court.
I would like to start off by saying that my heart goes out to the kids, the mother, the sister, the grandmother, the grandfather, the whole family. And I'm not saying that the events that transpired that night were not my fault. And as my attorney said, I will accept responsibility for my part. And whatever God has in store for me, God has in store. Whatever His will is today, whatever your sentence you impose me of is going to happen regardless. And I've had plenty of time to make my peace with that. I just hope that they get some sort of understanding and some sort of closure. And I hope that they may be able to try and find peace. And I mean, that night, yeah, I was suicidal. Yes. And it should have been me. It should have been her. And I've had, like I said, I've had plenty of time to think about everything. I've been put on a dream blocker because I have nightmares now, and I mean, I still see things. Because in all reality, like, I was very happy with her and the kids. I loved her with every piece of my heart, my soul, everything. And if I could go back and change it, I would. But there's nothing I could say that's going to change anything. And now 3 bright kids have to grow up without their mom. And her mom has to live without a daughter, or sister without a sister, grandparents, granddaughter. And I really hope that the Lord helps show them peace and gives them some sort of closure, no matter what happens to them.
Thank you.
That's the problem, Michael. It's true. Nothing he says is going to change what happened. It's not going to bring them back. And I think that's part of the reason relatives are so angry that he was allowed and offered to plead guilty to involuntary manslaughter instead of murder.
Yeah, he claims it's suicidal. I struggle because why are you still here and
she's
dead?
Gone. Right. All right, let's bring in criminal defense attorney Josh Schiffer to discuss just that. And Josh, the fact that he says this gun accidentally went off, that this was an accident, the state pled it down from murder to involuntary manslaughter, which is why he was allowed to plead to that.
Yeah, and this is where judges have literally the hardest job out there, because it's not about what the family of the victim or the decedent feels, as awful as that is. Their input is super important. We need to hear from them. They're the only voice for this person who's not here anymore. But from the defense perspective, I know some people might be a little bit taken aback by how clinical and abrupt the defense attorney was with, we've said this was an accident from the beginning. We've been trying to go forward with this as an accident. I was prepared to try the case as an accident. And that's then where the context for sentencing should be set. And that's a very different sentence than anything more intentional or more culpable, which is gonna lead the court to arguably, if they're fair, and I believe they're going to be, issue a sentence that's gonna upset people because they believe in their heart of hearts that this was an intentional, violent act. And it's hard to bridge that gulf. The district attorney already had to eat some really heavy workload emotions by telling this family, hey, we can't prove what we want. We're gonna have to go with this reduction in order to achieve justice. Otherwise, we might lose it all.
Look, I get on prosecutors sometimes for overcharging, et cetera. This one, boy, I feel it's the exact opposite, Josh, and I have a problem with it. Because again, when I look at the facts of the case and just listening to what the prosecutor had to say as she argued for the maximum in this case, this is a guy that I think needed to go to trial. This sounds to me, Josh, like a classic domestic violence murder. This was the day she was going to leave him. She ends up dead. There's really no surprise there. We see this over and over. And, you know, we talk about the 45 minutes that he left her there after he shot her. That alone can give you intent. Are you surprised that they would plead not just down to manslaughter, but all the way down to involuntary manslaughter and basically take the defense's version of events?
Not surprised, because it's a domestic violence case. These are the most difficult factually for the state to deal with, and there's a huge chance that one or more jurors sides with the defense because they've got that connection. So I support the state's reduction. They knew what the possibility of trial was going to be.